Hello everyone, today we're going to talk about what a preliminary hearing is. So this is an early court procedure for felonies only. These are serious crimes such as robbery or murder, not minor offenses like misdemeanors such as petty theft or infractions like traffic tickets. And a preliminary hearing happens after you've been arraigned on a felony, after your first court appearance, before the full trial. It's essentially like a checkpoint to decide if there's enough evidence to send the case to trial. So at the hearing, the prosecutor has the burden of showing probable cause or strong suspicion that the charges alleged against you by the DA's office were committed by you by presenting police, victim, or witness testimony, as well as documents, records, and photos. So the judge hears this testimony, looks at what is presented, and decides at this hearing if there's enough evidence to support the criminal charges against you and whether the charges should move forward using the standard called probable cause, meaning they just need a strong suspicion or a reason to think you did the crime, not to prove the crime completely. So you get a defense lawyer. Your defense lawyer can ask questions, call witnesses, they can cross-examine witnesses, they can present evidence, but it's not common for the defense to have many of their own witnesses or evidence to be presented at prelim, because this is primarily the prosecutor's time to show they have enough evidence to move forward with the case, not a time to have an entire trial. So at the end of the preliminary hearing, the judge will ask for arguments, and your defense lawyer will likely make a 995 motion to dismiss some or all the charges based on insufficiency of the evidence. This means arguing that some facts necessary to support the charges were not shown at the hearing, and therefore the charges should be thrown out. And the defense attorney can also make a 17B motion to reduce some or all the charges, and this will be arguing that a less serious charge than the one alleged should apply based on the facts shown. So the defense attorney can make arguments supporting those motions, but you can't be found guilty at the prelim. It's just to decide if the initial charges should keep going forward at the trial stage. So if the judge has a strong suspicion to believe the charges were committed, the judge is going to want a jury to have the opportunity to hear the charges and the facts of trial, and for the jury to make a determination and decision as to whether or not you're guilty of those charges based on the facts. If the judge finds probable cause exists that the crimes were committed, the judge says yes to the charges and the case moves forward. If the judge says no, the whole case or some of the charges might stop. In other words, they might get dismissed or lowered to lesser charges. The prosecutor could try to file the charges again if they are not successful, because double jeopardy does not apply to prelim, and the prosecutor may even amend the complaint to add more charges if some new, more incriminating information is revealed at preliminary hearing, but both of these situations are rare. Now, to be more specific, the preliminary hearing in California occurs after arraignment and before trial, and is an evidentiary proceeding to protect defendants from wrongful prosecution in felony cases. So it does not apply to misdemeanors, which carry lighter penalties such as jail sentences of a year or less, and there's not as much danger of severe punishment in the case of wrongful prosecution. So the prelim is often likened to a mini trial. Its primary purpose is to determine whether there's sufficient probable cause, and this is defined as, quote, a state of facts that would lead a man of ordinary caution or prudence to believe and conscientiously entertain a strong suspicion of the guilt of the accused under the Ullman case from 1973. And the prelim is to justify holding the defendant for a full felony trial. It involves two key determinations. First, that a public offense was committed based on the facts presented, and second, that there's sufficient evidence to believe the defendant committed it, which links them to the crime. So the standard is rooted in California Penal Code sections 871 and 872, and it's a low burden compared to the beyond a reasonable doubt threshold required at trial. And again, this mirrors the probable cause needed for an arrest or to apply for a warrant.